Division's hearing by affidavits. I have several technical examiners with me this morning. The first is Mr. Dean McClure. He's going to handle about the first 18 cases or so. So let's get on the record and let's get going in Riley Permian, case number 25358.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak, appearing on behalf of Riley Permian.
Good morning.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador Production. And we just entered an appearance and we are not objecting as far as I understand.
Perfect. Thank you. Who do we have from EOG? Mr. Suazo, do you know who entered on EOG's behalf?
I believe it was Ms. Kessler.
Okay. Okay. Why don't you proceed, Mr. Suazo?
Sure. As you recall, this case was continued to follow up on some items that Mr. McClure asked for. And so, this is Riley's requesting one application to approve a standard horizontal spacing unit and compulsory pooling. The lands at issue here are 481.47 acres, more or less, comprising of the north half of Section 12, Township 18 South, Range 26 East, and the northwest quarter of Section 7, Township 18 South, Range 27 East in Eddy County, composed of the following wells: Marty Fee 11-7 1H through 4H, that are set to produce in the Red Lake Glorieta Yeso Formation. We filed an amended exhibit packet in this case on July 31st. Exhibit A of that packet is the compulsory pooling administrative checklist. Exhibit B is the application filed on April 8th and the proposed notice of hearing filed on April 24th. Exhibit C is the affidavit of senior landman Mark Smith, who has previously testified before the division, and his qualifications have been accepted and made a matter of record. Exhibit C1 through C6 are the standard suite of land exhibits, location map, C102's acreage of the unit, plat and tract ownership. These are the exhibits that were amended in this case per the direction of Mr. McClure. There are updated figures in C-3 and C4 depicting unleased mineral interest owners. There's an updated CPAC, updated C102 for the 11-2H, noting the well as the defining well, as the division has requested. Exhibit D is the affidavit of senior geologist Doug Standert, who has also previously testified before the division, and his qualifications have been accepted as a matter of record. Exhibits D1 through D5 are the standard suite of geology exhibits. And finally, Exhibit E is the notice affidavit showing that notice letters were mailed on April 18th of this year, and again on June 10th of this year, to the addresses of record to the interested parties, along with mailing receipts and publication in the Carlsbad Current Argus. And with that, unless there's any questions, I'd like to request that these exhibits be admitted into the record and these matters be taken under advisement.
Thank you, Mr. Suazo. Without objection, Mr. McClure?
Mr. Hearing Examiner, I do have questions for the landman in this case.
Okay, Mr. Suazo, would you get your landman?
You bet. It's Mark Smith. I think he's online. I'm told he's trying to log on now. But looks like he was thinking we start at 10 and he might be running a little late, so apologies.
Mr. Hearing Examiner, this is Jordan Kessler on behalf of EOG. I also thought that we were starting at 9 a.m., so please forgive me. I would like to enter my appearance in this case.
Thank you. Good morning, Ms. Kessler.
Sorry, I'm looking for him to sign on. Okay, I see Mr. Smith online now, Mr. Examiner. Mr. Smith, do you mind turning on your camera and microphone?
Yes. You, you know,
I hear him. It's kind of garbled.
here at the all hooked up, but I assume you guys still cannot hear me. Is that correct?
Nope, we can see you and hear you now. Mr. McClure has some questions for you based on the revised exhibit packet that we filed. Mr. McClure, go ahead.
No, excuse me, before he goes ahead, we got to get him sworn in.
Oh,
Mr.
sorry.
Smith, would you raise your right hand?
Yes, sir.
Perfect. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
State and spell your name for the record.
My name is Mark Smith, MarkSmith.
And you've been accepted as an expert in what field before this division?
I'm an expert in land. And
Perfect.
Yes, I have.
Perfect. Thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Smith, I guess I don't know if you have it in front of you or able to see it on your phone or not, but I'm looking at your amended exhibit C3.
Yes, sir.
Okay, and
I've got it in front of me.
very good. And you see where I'm looking at your track map itself. It's on the, well, page 25 of 73 of the amended exhibit packets where it shows 3 different tracks. Are you on the same page as I am?
Yes, sir.
Okay. At the last hearing, or was it you that testified at the last hearing, Mr. Smith?
Yes, sir.
Okay. At the last hearing, you'd referenced 22 different tracks. Were a number of those tracks identical ownership? Is that why we're only seeing 3 tracks here? Or can you please provide me a
Yes.
description otherwise as to what we're looking at?
Yes, that's correct. Yes.
Okay.
Yeah. So what I did for you was identify basically the 2 tracks where the unleased acreage is situated. But the other owners I referenced and before are undivided owners across that entire yellow outline.
Okay. So all of track 1, does it have identical ownership across all the interest owners then?
Correct. Yes.
Okay. Now I'm wondering if maybe I'm missing it. Maybe there's a missing slide or something here. Do you reference what the owner, do you break down the ownership anywhere here for each of these 3 tracks?
Yes, the net unleased acreage in tracks 2 and 3 show the ownership. And then I've got the unleased owners as well on page 6 and show which track each owner is within of tracks 2 and 3.
Do you know what page that is in the exhibit packet?
I believe it's page 6 on the exhibit C4 continued.
I believe if I can chime in on the exhibit packet, it is page 27, or sorry,
Okay.
starting with page 26.
Okay, I think I'm looking at page 26 here, and there's a table with, I don't know, like a dozen different interest owners listed out, has status as uncommitted for some and committed for others. How does this relate to the breakout of ownership for each of the tracts?
That's not the one I was referencing.
Oh,
Try looking at page 28, Mr. McClure. I think Mr. Smith might have a different page compared to what we're looking at based on what's filed. So I'm trying to orient everybody.
Okay, I'm looking at page 28, and this says unleased mineral owners. Then it has 5 different interest owners listed out. And it does reference like Dan Wallace Erlin, interest within track 3 as described on exhibit C3. Is that what you're looking at, Mr. Smith?
Yes, sir.
Okay, now this references that it's described. Are you referencing that track 3 is described in exhibit C3, or are you referencing that the ownership is described in exhibit C3?
I'm referencing that Dan Wallace owns his unleased mineral interest is within tract 3 as depicted on the visual that I provided that shows tracks 1, 2, and 3.
Okay, now how much interest does Dan Wallace Erlin own in track 3?
Okay. I don't have that. I don't have the exact decimal for each individual owner there. So I just have the total unleased acreage of 5.95 acres between these unleased owners. So I do not have that decimal right next to their names.
And do you have a breakout of the working interest owners other than these unleased mineral interest for track 2, 3, and 1 listed anywhere?
For the committed or uncommitted?
For the entire summary of interest, regardless of whether they're committed or not.
Yeah, I have all the working interest owners' decimals and their net acres listed on the uncommitted and committed summary.
Page 26. And it notes it in the last column whether they're uncommitted or committed.
Okay, I see that table, but I guess what my question is, do we know how much 1789 Minerals Fund number 2 owns in track 1?
23.664 acres.
That's in track 1.
Correct.
Okay, and is it okay, well, we'll drop down to the unleased minerals. Do you have it listed here anywhere where it says how much is in track 1 of that?
The unleased mineral owners are only within tracks 2 and 3.
Would it be fair to say that this table does not provide a breakout between the 3 tracks?
It doesn't specifically list which tract on this specific table.
And is that information included anywhere in your amended exhibit packet?
What I had amended, which is what maybe I misunderstood what you were wanting from the last time, was to specifically identify where the unleased mineral owners were situated within the DSU. So that's what I attempted to do, was show exactly where the unleased mineral owners were situated, which I have depicted there in tracks 2 and 3, making up 5.9 acres.
Okay, if I were to tell you that what we're needing to see is like a table with like track 1 and then all of the working interest owners listed with their percentages for track 1, and then track 2 with all of the interests listed there for track 2, and then the same for track 3. Do you understand what I'm asking for?
I do understand this new request. Yes, correct.
Okay. Very good. Mr. Hearing Examiner, I don't have any further questions, but I would request of Mr. Sazo, or I apologize, sir, I'm mispronouncing your last name, but that we get an amended Exhibit C3 submitted, as I just requested of Mr. Smith.
Thank you, Mr. McClure. Mr. Suazo?
Sure, that's not a problem. We can get that put together and submitted. I take it that we can have this case taken under advisement if we can get that submitted, let's say by COB tomorrow.
No, the case would have to be continued to the next hearing by affidavit docket or potentially a special docket so that Mr. McClure has time to review the exhibit and ask additional questions if necessary.
Well, I feel like this is more of a minor, change just because it's all there. He just wants it broken out slightly differently, more granularly reflected. Does that make sense?
Let me ask Mr. McClure. Mr. McClure?
Mr. Hearing Examiner, I would hesitate to take it under advisement with the record left open. We made this request prior and it wasn't fulfilled, I guess, as requested.
Okay, thank you.
I mean, I'm not sure I agree with that. It sounds to me like he's wanting it just a little bit differently than was explained. I mean, we could go back and look at the record, but I feel like this is relatively minor. The information's there broken out. He just wants it broken out further.
Mr. Suazo, we have a special docket next week on Tuesday and Wednesday. If you want to continue your case to one of those dockets, I would accept that.
Okay, that is fine. Thank you, Mr. Examiner. Really appreciate it.
Okay. Anything further, Mr. Suazo?
No, Mr. Examiner.
All right, we're off the record in that case. Let's call COG operating cases. These are 4 cases that are joined. This is 25440, 41, 42, and 43. Entries, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of COG.
And Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Devon Energy Production.
Thank you.
May I proceed?
Please.
So we actually filed a late file, a motion for continuance yesterday to the September docket. What we need to do is we got some updated C102s and we just wanted to make sure so we don't have any additional back and forth that we review those C102s and update the compulsory pooling checklists if needed. So we would just request to be on the 9/11 docket.
That sounds good. We'll put it in the beginning of the 9/11 docket.
Thank
so
you.
that it doesn't get bumped by accident. Mada-E, would you make a note of that? Thank you. Anything further?
No.
All right, we're off the record in these 4 cases. Let's go to number 6 on our docket. This is Mewburn Oil 25435.
Mr. Examiner, Jim Bruce representing Mewburn.
Okay, good morning.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Devon Energy Production.
Had you objected?
No objection.
Had you objected?
Oh, no, we did not. We are just monitoring. This
Okay, thank you. Mr. Bruce?
Mr. Examiner, this matter was heard on July, I guess it's 10th, and was continued to this hearing for submittal of some corrected exhibits. I have filed corrected exhibit packages. In particular, Exhibit 2B, Exhibit 1, the pooling checklist was corrected as to a footage location on the well, on one of the wells. Exhibit 2B was revised to list or to correctly outline the well unit being pooled, and then the cross sections, Exhibit 3D and 3E. Mr. McClure wanted higher resolution cross sections. I tried, but I probably failed to file those. I did get new cross sections there. They were submitted in the revised exhibit packages, but I did forward to Mr. McClure this morning copies of the two cross sections that I know can be expanded on his computer so he can get the resolution he desires. And with that, I'd ask that the matter be taken under advisement.
Okay, let's get your exhibits admitted there without objection. Mr. McClure?
Mr. Hearing Examiner, I have no questions for the case. We just need to figure out what procedure we want to use to get these cross sections into the case file. What Mr. Bruce emailed me will be sufficient resolution once it's there, I guess. I don't know what your thoughts was in regards to getting it in there, though.
Okay. Were you able to review the cross sections that he emailed you?
That is correct, Mr. Hearing Examiner. They are fine and sufficient,
All right, sounds
and
good.
I did
do you-
review them.
Okay, great. And do you have any questions for any witnesses?
I have no questions, Mr. Hearing Examiner.
Fantastic. Mr. Bruce, we can take this case under advisement once we get the proper filings.
Okay, I will try. My problem is I'm my own IT department, and there's not too much intelligence in that department, so I will do what I can.
So
I'm kind of tired for a couple of days on another matter before the division, so I will get it taken care of early next week.
no worries. Mr. Bruce, do you use Adobe Acrobat?
Yeah, I don't know really well how to use it, and Mr. McClure did email me some instructions, so I'll try to go back and fix that.
So in Adobe Acrobat, there are different tools that you can use to create a PDF. And one of the tools allows you to combine other PDFs into one document.
So I understand, and so I will find out, Mr. Examiner.
All right. So, Mr. Bruce, so that this doesn't get away from us, when I know you have some stuff going on next week, since I just emailed you, when do you think you can have a revised exhibit packet with a cover letter for Mr. McClure to review?
Would Wednesday be okay, sir?
Of course, we can make it Friday of next week. I have no problem with that. Let's give you a little more time. So let's say that by the close of business on the 15th of August, you will have filed in the case file one exhibit packet that is revised and a cover letter attached explaining what you're doing.
Okay, thank you.
And then we'll take the case under advisement, so you don't have to continue the case if you get that in by the close of business, the 15th of August.
Thank you.
All right. Thank you, Mr. Bruce. Moving on, off the record in that case, moving on to another Mewbourne Oil case. This is 25417.
Mr. Examiner, Jim Bruce representing Mewbourne.
Are there any other parties? I don't think there are.
There are not.
Okay, go right ahead.
Mr. Examiner, again, this matter was heard on July 10, and you asked for a more complete ownership list and a new exhibit. The exhibit package was refiled with a new ownership list, Exhibit 2B, and so we complied with the division's request, and I'd ask that the revised exhibits be admitted and the matter be taken under advisement.
Thank you. Without objection, Mr. McClure?
Mr. Hearing Examiner, I have no questions for this case.
Mr. Bruce, this case is taken under advisement.
Thank you.
Calling now case number 25429, Mewbourne Oil.
Mr. Examiner, Jim Bruce representing the applicant. I do not believe there are any other parties.
Perfect. Go right ahead.
Mr. Examiner, once again, this matter was, these two cases, or this case, I should say, was heard on July 10th, and it was continued to correct exhibits. Exhibit 1 was revised per Mr. McClure's request to change the interval being pooled in this case. Exhibit 2B, the ownership plat and the list of interest owners was revised to include all interest owners, not just those being pooled. And Exhibit 4A, although it wasn't requested, adds some additional green cards and returned letters. And Exhibit 4B, the spreadsheet was corrected. And again, Mr. McClure requested better resolution cross sections. I think those came through in the exhibit package, but again, I did submit this morning cross sections that I know Mr. McClure can expand on his computer. But if Mr. McClure says the ones that were in the exhibit packages are insufficient, I'll try to do the same thing as I'm supposed to do for case 25435 and get something to you. With that, I'd move the admission of the exhibits and ask the matter be taken under advisement.
Thank you. Without objection, Mr. McClure?
Mr. Hearing Examiner, the cross sections that are currently submitted are sufficient for this case, and I have no questions for this case.
Thank you, Mr. Bruce. This case is taken under advisement.
Thank you.
Calling Admiral Permian 25335.
Good morning, Jackie McLean with Hardy McLean on behalf of Admiral Permian and also entering an appearance on behalf of COG Operating and Concho Oil and Gas.
Thank you.
And I believe it erroneously says Mewburn, but it's Matador that is the other party.
Good morning, Mr. Hearing Examiner, Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Matador.
Any objection, Ms. Vance?
No.
Ms. McLean?
Yes, we're back for case number 25335 because we were asked at the last hearing to submit an amended exhibit B5 to include API numbers and well names on the stratigraphic cross section. We did that on July 30th, and at this time we'd ask that the case be taken under advisement.
Perfect. Thank you. Without objection, Mr. McClure?
Mr. Hearing Examiner, no questions for this case.
The case is taken under advisement. Thank you, Ms. McLean.
Just, can I make one correction?
Go ahead.
It's actually Mr. Bruce who entered an appearance on behalf of Matador, not myself. So I apologize for that.
Okay. Mr. Bruce, are you there? Guess not.
Yes, she's correct.
Sorry, Jim.
So would you like to
no,
make...
my self-muted, so I was a little slow in responding. So
You want to make an entry of appearance?
yeah, for I think it's MRC Permian.
I don't know,
is
Mr.
it?
Bruce. Yeah, I don't know.
Well, whoever, it's either MRC Permian or Mewburn Oil Company.
It's MRC Permian Company.
Okay,
MRC Permian.
thank you.
And no objection?
No objection to anything.
Right, thank you. Okay, let's go to number
That whole time.
10 and 11 on the docket. These are Avant operating cases 25347 and 48. Entries, please.
Good morning, Yaritza Pena with Module Sperling on behalf of Avant Operating 2 LLC.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of MRC Permian.
Thank you.
Mr. Examiner Dana Hardy with Hardy McLean on behalf of Permian Resources Operating.
Thank you.
And good morning,
Ms.
Mr. Hearing Officer Gabrielle Gerholt, entering her appearance on behalf of Civitas Permian Operating this morning.
Good morning. Ms. Gerhold, did you enter an objection?
We withdrew our objection.
Perfect.
We have withdrawn our objection to both cases.
That's perfect. Thank you. I appreciate it. Ms. Vance, did you enter an objection?
In these previously, I believe that we did, and we withdrew it. Yes, sorry. I just need to look back and I remember our conversation. So yeah, no objection to these moving forward.
Ms. Hardy, the same?
Permian Resources did not object.
Never
Monitoring.
objected. Okay, thank you. Ms. Pena?
Thank you. There's another party. They just don't appear. Paloma Permian had entered their appearance as well.
Is that Mr. Jewell up in Colorado?
That's correct.
All right, go right ahead.
So we're also here on a continuance from the July 15th hearing where I previously presented these two cases. And we have submitted an amended exhibit packet once on July 22nd for Mr. McClure's changes with the revised compulsory pooling checklist in both cases, identifying a proximity track well, and an amended A6 in case 25347 to include a missing slide in the summary of contacts. And yesterday we submitted an additional amended packet in both cases with an updated summary of interest in Exhibit A4 in both cases, showing that Avant 2 acquired an additional interest, so those percentages were updated and also the pooled parties list was updated. And with that, I would ask that the cases be taken under advisement.
Thank you. And that's in both cases?
Yes.
Okay, and without objection, Mr. McClure?
No questions for either of these cases.
Thank you, Ms. Pena. They're both taken under advisement.
Thank you.
Moving on to BTA Oil Producers. There are two joined cases, 25411 and 12.
Good morning, Jackie McLean with Hardy McLean on behalf of BTA Oil Producers.
Thank you.
And,
Ms.
sorry.
Bennett?
And Yoritza Pena with Module Sperling on behalf of Avant Operating 2, LLC.
Thank you.
And in these cases, we were asked to come back so that we could include revisions to depth severance information that was contained in the compulsory pooling checklist, Exhibit A and Exhibit B. And we submitted the amended exhibit packets on July 23rd and would ask that the division take case numbers 25411 and 25412 under advisement.
Ms. Pena?
No objection.
Thank you. Without objection, Mr. McClure?
No questions for either of these cases, Mr. Hearing Examiner.
Thank you. They're both taken under advisement.
Thank
Let's
you.
move on to Cimarex Energy. It is number 14 on our docket. It is 25423.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Aberdeen and Shield appearing on behalf of Cimarex Energy Company of Colorado.
Thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Permian, and we are just entering an appearance and preserving rights.
Perfect.
Good morning, Mr. Examiner. Jordan Kessler, representing EOG Resources, similarly entering an appearance, preserving rights.
Thank you.
Mr. Hearing Examiner, today Cimarex is following up to confirm that the original hearing packet submitted in case number 25423 has been satisfactorily amended and revised so that the case can be taken under advisement without concern. Cimarex revised the original hearing packet by including an amended Exhibit A2 that breaks out and shows the interests of the owners in each tract of the unit. Also, Cimarex has included amended Exhibits B4, B6, and B8, in which the depth was revised to 100-foot spacing on the depth tract, and in which the geologist has also added a tick for the 50-foot mark. Based on these revisions, Cimarex asks that the amended hearing packet be admitted into the record for this case and the case be taken under advisement.
Thank you. Without objection, Mr. McClure?
Mr. Hearing Examiner, I have no questions for this case.
Thank you. We'll take this case under advisement. Let's move on to Burnett Oil, number 15 and 16, 25427 and 28.
Mr. Examiner, Jim Bruce representing the applicant.
Mm-hmm.
Good morning, Mr. Examiner. Miguel Suaza with Beatty and Wozniak representing Riley Permian for monitoring purposes only.
Thank you. Mr. Bruce?
Yes, Mr. Examiner. Once again, these cases were heard on July 10th and were continued to revise some exhibits. That has been done. I will have a comment on a couple of items at the end of it, but Exhibit A3 in each package, which has the tract ownership and shows who was pooled and who is not, was revised, was updated to be current. Exhibit A5, the summary of chronology or chronology of contacts was updated. Exhibit 3, the cross-section was revised to have higher resolution. And exhibits D1 and D2 were supplemented to show all return receipts and to submit the certified notice spreadsheet. So all of these exhibits are correct, but something came up this week. And I would ask permission to submit second revised exhibit packages for the following reason. And if you have any questions, the landman is online to answer your questions. But when we first went to hearing, we were going to pool 4 groups of people, all from the DISQ, D-I-S-Q-U-E family, but they contacted Burnett and asked not to be pooled because they were going to execute leases in favor of Burnett. And so that was fine with Burnett. We did not put them in the exhibits A3 and A5. Well, just a couple days ago, they emailed the landman at Burnett and said, oh, we executed 3 of the 4 leases, but we got a better deal from someone else, so we're taking that deal. So they reneged on the deal, and so we plan on revising exhibits A3 and A5 again to show that these 4 groups in the DISC family are being pooled. We feel we have to do this to make sure that everyone is pooled and that Burnett's interests are protected. And so that's what I intend to do probably this weekend. Is I've already got the exhibits, revised exhibits in front of me. I just need to get the time to stick them in the exhibit packages. But that's what I plan on doing. And if you have any questions about these issues, Christine Pilgrim is the landman and she is online.
So are there any exhibits for me to admit today?
Yeah, I've got exhibits A through E in each case that I asked be submitted into evidence.
Okay.
Admitted.
Okay, Mr. Bruce, without objection. Mr. McClure?
Mr. Hearing Examiner, I guess a quick clarifying question for Mr. Bruce. Mr. Bruce, so essentially persons that were not originally being requested to be force pulled by the division is now being amended, that now Burnett is asking the division to force pull them. Is that correct?
That's correct. They were all notified of the hearing. And as a matter of fact, Burnett has been dealing with these people for 2 years now. But they asked to be omitted from the people being pooled, and then they reneged on their deal with Burnett. And so we're putting them back in the list of parties being pooled is the only way to make sure that we pool everything we need to. And then there's one other thing. A company named SEP Permian did sign up for the well and is removed from the revised exhibit packages.
Now, Mr. Hearing Examiner, I guess my only hesitance on it is just that we're changing from what was the application they were originally noticed of is now being changed to force pull them. But in theory, if they were following the case, I guess I don't know what your thoughts are on whether we need to renotice them or not.
Mr. Bruce?
Well, they were notified of the applications and they obviously received them, and that's in the notice exhibits. Plus, they're the ones who contacted Burnett to ask that they be removed from pooling, which we agreed to. But then when they reneged the deal, we do have the application didn't change. Their agreement to lease to Burnett obviously changed because they reneged on their deal.
So, Mr. McClure, do we need additional evidence, or do you? It sounds to me like they've received notice, proper notice. and their status has changed, and now they're being force pooled. Do you need additional evidence to support any order you issue?
Mr. Hearing Examiner, I don't have strong leanings one way or the other on the notice question. If you're satisfied with notice, then we should be able to take it under advisement. Well, once we get the amended exhibit packets, I guess. I don't know if you want to continue for that or not.
Why don't we get the landman on the, let's get him under oath and ask a few questions. Mr. Bruce, your landman?
Christine Pilgrim.
When I first logged in, my camera was working, but now for some reason my camera is not wanting to work.
All right. Well, I'm not gonna swear you in, Ms. Pilgrim, until your camera is working, so we can go into recess on these cases and come back when your camera is working.
Okay, yeah, I could log out and I'll log back in to get it working.
Sure, Mr. Bruce. When you communicate with Ms. Pilgrim and when she gets her camera working, let me know. And we'll come back to these cases, okay?
Okay, thank you.
All right, we're in recess in these two cases. Let's go on to San Juan Resources. This is number 17 on the docket, 25475.
Good morning, Mr. Hearing Examiner. Ann Tripp on behalf of San Juan Resources Incorporated. And
Okay,
no other parties have entered their appearance.
Okay, can you spell your name?
Yes, my first name is spelled Ann, A-N-N. My last name is spelled T-R-I-P-P. Is that purple,
Okay,
purple?
Okay, very good. Thank you. Okay, go right ahead.
Thank you, Mr. Hearing Examiner. So I'm here on behalf in case 25475 of San Juan Resources Incorporated, and we're seeking an order from the division acknowledging the McSims Mancus Federal Exploratory Unit that's been approved by the Bureau of Land Management. The unit consists of approximately 7,094 acres, consisting of 77% federal lands and 23% patented or private land, all located in Rio Arriba County. In the hearing exhibit packet that we've submitted, consisting of exhibits A, B, and C, online with me this morning is Mr. Jerry McHugh. He's our land affiant. And then Mr. Rich Bosher is also online for geology or geological testimony. Both have been previously testified and credentials have been accepted as a matter of record before the division. I will note that 99.1045% of the working interest in the unit has been voluntarily committed, leaving less than 1%, 0.89543. Regarding notice of this application for the division acknowledgement of the unit, we've provided notice to all the non-committed working interest owners, as well as the non-committed or non-ratifying royalty interest and overriding royalty interest owners. Exhibit C contains my affidavit regarding notice. The chart, Exhibit C2, is significantly longer than the parties identified in Exhibit A4 because some were deceased. So we proceeded to research and notify as many family members or heirs as we could determine from public records. And so I'll submit this Exhibits A through C for the matter to be taken under advisement.
Okay, thank you, Ms. Tripp. Without objection, Mr. McClure?
Mr. Hearing Examiner, I have questions for the landman for this case.
Ms. Tripp, your landman?
Yes, sir, Mr. Hearing Examiner. Jerry McHugh is our landman, and he's online and appearing via camera.
Hello.
Okay, there you are. Mr. McHugh, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Spell your name for the record.
Jerry, MC, capital H, UGH.
Thank you. And you
And
have
I'm
been
junior, comma JR.
you've been accepted as an expert before this division?
Yes, I have in the past.
In what field?
Land operations, just putting
Okay.
projects together in the San Juan Basin.
All right, thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. McHugh, The unit agreement that is included in these exhibit packets, is that the final unit agreement?
I believe it is. Yes, sir.
Okay. Within the BLM approval letter, there's reference to 2 obligation wells. Are you familiar with what I'm referring to?
Yes, sir.
Okay. Is that requirement within the unit agreement, or is the BLM just requiring that above and beyond the unit agreement?
That is, my understanding is within the unit agreement. So in other words, for the unit to be continued and in effect, the 2 wells are obligation wells.
Now, within the unit agreement, would that be within their paragraph 9 or whatever nomenclature they use for that number 9?
I'd have to pull that up and look at it. What do you see there, Ann? See here.
But Ms. Tripp, are you able to share it with us on the screen?
Yes, I should be able to. Just a second.
I believe it's page 11 of 131 as paragraph 9.
All right. Can you see, this is the unit agreement exhibit A2. It's at page 11. I can't see what you're seeing from my screen. Is that displayed?
It is showing up. If you can scroll down to their paragraph 9 that they have.
Absolutely. So paragraph 9 is drilling to discovery. It starts at line 39 on page 11.
Mr. McHugh, do you see what your attorney is sharing with us?
Yes.
Do you see where there's reference to the 2 obligation wells here, or is it somewhere else within the unit agreement?
That's that paragraph 9 is a stipulation, which spells out, the BLM unit requirements for unitized substances. Capable, from line 45, capable of being produced in paying quantities. In quantities sufficient to repay the cost of drilling, completing, and producing operations with a reasonable profit. Unit operator shall continue drilling 1 well at a time, allowing not more than 6 months between the completion of 1 well and the commencement of drilling operations for the next well. So that really spells out the BLM parameters for doing that paragraph 9.
Would it be accurate to say? Oh, go ahead, sir. Go ahead.
The 2 well commitment, I think, is up above there.
Oh,
sorry about that.
Do you know where that might be located at, Mr. McHugh?
Maybe Ann can scroll up maybe a page.
Absolutely. I know there's a description of the obligation wells at the end of the unit agreement as well. I can scroll. Well, all right. I'm going to stop sharing very briefly so no one gets dizzy as I go through this. Just a second.
I don't have it pulled up here. My main assistant is off this today and tomorrow, so we're digging this up through our
Sure.
efforts here.
So Exhibit D to the unit plan of development and operation. I'll share my screen again. So let me know, Mr. McHugh, can you see Exhibit D, unit plan of development?
Right. Yes.
Operation. So this is an exhibit that's made part of the unit agreement, and it describes the obligation to drill the obligation wells.
Yes.
And this is page 34 of 131 pages of the hearing exhibits. It is on just a little bit unlabeled in terms of following the unit agreement. It follows Exhibit B to the unit agreement, which is the description of all the interest owners, and Exhibit C is the, I believe it's the plat of the areas.
Okay, thank you, Mr. McHugh. So it would be accurate then to say that what you have included here is the final unit agreement in the exhibit packet. Then is that correct?
That's right. That's our unit POD.
Okay, and the unit agreement is executed, the one that's submitted. Is that correct?
Yes, sir. That's correct. We've submitted that with the BLM under their requirements.
Thank you, Mr. McHugh. Mr. Hearing Examiner, I have no further questions for this case.
All right, thank you, Ms. Tripp. We'll take this case under advisement.
Thank you, sir.
Moving on to number 18 on the docket.
Thank you.
Let me go back to Mr. Bruce. Mr. Bruce, did you get your landman on the screen?
Yes, I am here.
There you are. Okay. Mr. Bruce, are you with us?
Okay. Yes, I was muted. Yes.
Sounds good. Okay. Ms. Pilgrim, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but truth?
I do.
Spell your name, please.
It's Christine, Kristine, Pilgrim, Pilgrim.
And you've been accepted as an expert before this division?
Yes, sir.
In what field?
For land.
Thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Ms. Pilgrim, just to remind us, which persons is it that Burnett is now asking the division to force pull?
Yes, and they were on the July 10th exhibits. Part of the, with us being moved this month on amending the exhibits was I was going to take them off for the exhibits for this month, but they were notified they were on the July 10th hearing, with this being the continuation of it. And it's Janine Witt Disc, Margaret Disc, and Paul Disc under the estate of John Walter Disc, and Jodell Disc under the estate of Jeffrey Disc.
Okay, and the amended exhibit packets that show that Burnett is now requesting the division to force pull them, those have not been submitted to us yet. Is that correct?
Correct. I gave those to Mr. Bruce. I just gave it to him, I think yesterday or day before yesterday. Yes.
Okay, and Ms. Pilgrim, is it accurate to say that these persons are very much aware of the change in status from not being force pulled to now being requested to be force pulled?
I have been in slight communication with her. She, the latest thing, I followed up on the leases. She mentioned that they had executed the leases, but then they got an offer to purchase their minerals and entered a PSA. And so I wrote back to her, and I just told her, I'm like, you did sign a lease first. I never received the lease. We didn't pay for the lease, so it was never actually delivered. But I told her she should tell her buyers that she had leased prior to, and she hasn't responded at all with me on this. And yeah, I said that for the July 10th hearing, I have been trying to reach out to these people for a couple of years now, and never heard a word from them until July 9th. So it was a very last minute decision that I was trying to be very understanding to their situation. And so I took it upon myself to go ahead and I'll go and take a lease and in return for taking them off the pooling. But yeah, they didn't hold up on that end. And we do have leases that are going to start expiring beginning of this next year. So it is, important to move forward if we can.
Thank you, Ms. Pilgrim. But let me re-ask my question, I guess. Is it accurate to say that these persons are aware that Burnett Oil is now requesting the division to force pool them?
No, I mean, they were for July 10th. And this is a continuation of July 10th. They were notified there.
Okay, is it accurate to say that the only avenue in which they were provided, the only avenue in which they would know that they're now force pooled, is it accurate to say that that is via this hearing today?
Yes, or the July, the July 10th hearing. I don't know how the notifications work. I mean, does everybody from July 10th hearing get re-notified for this one, or is it one notification for?
Ms. Pilgrim, I guess what my question is maybe I misunderstood, but I thought Mr. Bruce had referenced that you're in email communication with these persons and that you told them that you're now requesting to force pool them. But is that not the case then?
No, not re-adding them back to it. Because like I said, it was for in return for a lease, and they have not signed a lease.
I guess, Mr. Hearing Examiner, I don't think I have any more questions for Ms. Pilgrim. I don't know what your thoughts might be in regards to notice, though, whether that changed anything.
All right, thank you. Mr. Bruce, you heard the evidence in the case regarding notice. Do you have a legal argument to make?
Well, partially, if you're notified under division rules, if you're notified for the original case, you're notified for any ongoing proceedings. Plus, I can provide the division with an email from the discs to Ms. Pilgrim stating that they're making a deal with someone else. I think we're all adults in the room. You know, if you make a deal with someone else, all bets are off.
Okay, so the cite to the rule.
Oh, I can't give it to you off the top of my head, but it's in the notice that when matters are continued, you do not have the applicant does not have to re-notify everyone.
Okay, I'm not asking for that citation. I'm asking for the citation that they were originally noticed under what part of the rule?
They were originally notified that they were being pooled in these two cases pursuant to division requirements. I don't know how else to say it. The application, I just looked at the notice materials. They were noticed by certified mail and publication. And so they know there's an ongoing proceeding.
So I think there's two parts of the rule that talk to notice that would apply in this case. We have 1915-49. And that's the division publishing notice. And then we have 10 of the rule, parties to an adjudicatory proceeding. So, Ms. Pilgrim, when did you first provide notice to this party, the discs?
Like for our personal contact with the company, they were first noticed, February of 2024. Our brokers reached out. They were able to find a contact number, and left a few people voicemails. And then they received their first offer in April 24, and then a second offer with the proposals January of 25. And then
and did they get a proposal letter from you at some point?
Yes, that would have been in January of 25.
That's what I'm asking. Okay, so
Yes.
January, and you've provided evidence to that effect?
Yes, that's all. That'll be on the amended communication log.
Okay. So then we have 1915-412, and Mr. Bruce, I was hoping you could point to some of these rules for me. And I think this is the one that I'm looking for is A1A. The applicant shall give notice to each owner, et cetera, et cetera. And I'm looking for the number of days before. So Mr. Bruce, you've been doing this a long time. How many days notice do you need to give someone for the hearing?
The notice letter needs to go out 20 days in advance, and the way I interpret that, it's 21 days. I sent out notice on June 18th, so really the first day of notice would be June 19th, and that notice was timely. Then the notice was published in the Carlsbad paper, and that was published on June 19th. Now that is another reason. Now that was a day late, but that's another reason for the continuance is that the additional time since July 10th cured that defect, but they were notified by publication. And then of course the publication of the division of the docket by the division itself.
Okay, so you say you sent out a letter to them June what?
18.
Of what year?
This year.
Okay. So Mr. McClure, it sounds to me like these folks have been given proper notice.
Okay, thank you, Mr. Hearing Examiner. I guess the only request that I would have is Mr. Bruce offered to provide that email that they had sent to Burnett regarding not accepting the lease. If we could have them provide that along with the amended exhibit packet that they plan to submit.
Perfect. Okay.
Sure.
So Mr. McClure, for my benefit, what is this amended exhibit packet? What additional information are you requesting?
It should just be probably included the summary of contacts, just a copy of that email.
Oh, so is that but I thought you said that Mr. Bruce was already providing an amended exhibit packet. Was there something else besides the email?
Yeah, presumably, I don't have the exhibit number right in front of me, but presumably their table that indicates which persons they plan to force pool is now being amended to add these additional persons.
Okay, perfect. Okay.
Exhibits A3 and A5 will be corrected.
Okay.
They have been corrected, and I just need to submit them to the division.
Okay, and when are you going to do that?
If I could, because of my time deadlines today and tomorrow, I plan on doing it either at night or over the weekend, and you'll have them on submitted to the division by Sunday evening, so they'll be available Monday.
Okay, and Mr. McClure, are you going to want to do another review of the amended exhibit packet?
Mr. Hearing Examiner, yes, I will want to do that.
Okay, so Mr. Bruce, once you submit your amended exhibit packet, please continue these two cases to the September 11 docket.
Yes, sir.
Okay, thank you. We're off the record in these two cases. We've already handled number 17 on our docket. We're moving on to number 18. This is Hillcorp Energy, 25488. Entries, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Hillcorp Energy Company.
Are there any other parties?
I'm not aware of any, no.
Please proceed.
So in this case, 25488, it actually relates to a case we previously heard about, I think it was at the last hearing actually, or the one before that. And that case is 25437. We did not have an order at the time we filed this application, but essentially what we're doing is adding an additional well to that request for exception exception under the special pool rules. And the order for that previous case, in that case was 25437. That order number is R TAC 23892. So without further ado, so this is a request for an exception to the well density requirements under special pool rules related to the Basin Dakota gas pool, and that pool is 71599. In this case, Hillcorp has an existing unit. It's a 320 acre, more or less spacing unit dedicated to the pool I just cited. And it's in the east half of Section 36, Township 29 North, Range 8 West, San Juan County, New Mexico. And in that previous case, we requested to add 2 additional wells. And in this case, we're adding an additional, one more well under that request. And that well is the Statecom Q013Q well. And the exception here is that there will be 5 wells dedicated to this specific spacing unit, and the exception under the special pool rule, it allows for 4. So we're asking for a 5th well to be included to that spacing unit and dedicated to that pool. In our hearing packet, we have included a self-affirmed statement of Mr. Gatewood Brown, who is the landman. We have included with his statement, exhibit a notice area and the affected parties. Following that, we have a self-affirmed statement of Mr. Marcus Hill, who has previously testified, and his credentials have been accepted as a matter of record. With his statement, we have included a unit overview and targeted reserves. Also, a couple of maps that include original gas in place, cum gas produced, and then the remaining recoverable gas, all related to the pool, again, the Basin Dakota. And then lastly is a volumetric analysis. And then as required, I have my self-affirmed statement of notice that was timely. Those sample copy of the notice is included, and that went out on June 20th, 2025. And then lastly is the affidavit of notice of publication, timely published on June 19th, 2025. And we have both of our experts available for Mr. McClure. And without further ado, I would ask that this case be taken under advisement, as well as all the exhibits and sub-exhibits.
Without exception, Mr. McClure.
Mr. Hearing Examiner, I just have a quick question for Ms. Vance. Ms. Vance, the current thought process would be an order issued for this case will just supersede order R23892. Does that raise any concerns for you?
No, it doesn't. It's just, like I said, when we filed this, we didn't have the order number yet. So I just figured I would mention that and sort of assumed you would want to do that. So yes, I would request that the order in this case supersede the existing order.
Okay, thank you, Ms. Vance. Thank you, Mr. Hearing Examiner. I have no further questions for this case.
We'll take this case under advisement. Thank you, Ms. Vance. Moving on to number 19, this is Oxy USA, case number 25519. We have a different technical examiner for this case.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Oxy USA, Inc. And I do believe there are a couple of other parties that have entered their appearance in these cases. Or, no, I apologize. Yes, there are.
Ms. Kessler.
Sorry.
Why don't you continue, and if she chimes in, that's great.
Perfect. So I'll give a little bit of background on this case. This is a closed loop gas capture case. And actually there is Oxy filed a case related to some of the, related to this particular area. The original filing was case 23633. And I will say, Mr. McClure and I have already spoken about this case and a path forward to issuing an order similar to the last case. We're basically asking for a superseding order. So in the original case, there were 8 wells requested to be included under the closed loop gas capture case. And in this case that I'm presenting today, it's basically an expansion, and we're requesting to add an additional 17 wells to fully encompass the project. So in the hearing packet, we have included a copy, reference to the application. It's a large application, so I just put a reference in there rather than repeating. And then I've also included an additional slide and figures. And I just want to quickly explain that. And if you don't mind, I'm going to share my screen because I think it'll make it easier to understand. Let's see. So in our additional exhibits that we've included, we have an overview of all of Oxy's closed loop gas capture projects and where they stand in terms of pending approvals and existing approvals. And then this map we've included right here is an updated map to what was filed in the application. So what you'll see, this is an updated 2-mile mineral estate map, because if you go to our filed application, just so this makes sense, you'll see we only get to 1 mile up here in section 33. So to fully show that 2 miles, we've included an updated mineral estate map here that goes up further past 33 up into section 28. And I will note, as a supplement, we plan to file similarly a 2-mile surface estate map to meet the requirements under the division's guidance. Also included in our hearing packet are the statements of our petroleum engineer, Mr. Steven Janacek, and then our petroleum geologist, Mr. Jared Roundtree, and then our reservoir engineer, Mr. Rahul Joshi, all of whom have previously testified before the division, and their credentials have been accepted as a matter of record. Then that is followed by my self-affirmed statement of notice, which was timely sent out on July 18th, 2025. And then lastly is the affidavit of notice of publication that was published on July 19th, 2025. And I just wanted to add on a couple of just 2 other items. Like I said, we're going to file a supplement that will include a 2-mile of the surface. Additionally, we plan to file a gun barrel view of the wells and offsets. And then another additional supplement we plan to file is the OCD Exhibit A and B for the order. And then I will note that the specific requested relief in this case, and just to review it, is on page 1 of the application, again highlighting that this is a expansion of the existing case, and we're adding these additional 17 wells. And then also Oxy is requesting a maximum allowable surface pressure of 1,300 PSI. Also an exception to the 100-foot packer setting depth requirement applied to vertical injection wells, and then an exemption from the GOR gas allocation methodology as previously required under closed loop gas capture projects. And Mr. Janacek is available to answer any questions related to that. And with that, I would ask that the exhibits and sub-exhibits be admitted into the record. Obviously, we have some supplements to file, and I believe we can get those done by the end of August is our timeframe. So we would just ask to take it under advisement, but leave the case open so that we can submit those supplements.
Ms. Kessler?
Good morning, Mr. Examiner. Thank you for calling on me. This is Jordan Kessler on behalf of EOG. We've reviewed the exhibits in this case, and we do not have any questions or objections at this time.
Thank you. Okay, so without objection, your exhibits as they've been submitted are admitted into the record. And Mr. McClure is the technical examiner in this case. I was wrong when I said there's a different technical examiner. Mr. McClure?
Thank you, Mr. Hearing Examiner. I just had a quick question for the geologist.
Okay, and the geologist's name?
Mr. Roundtree?
Roundtree.
Hello.
I can't see you yet.
Okay.
But we'll find
Okay.
you. There, I think that was you. Is your camera on?
It is, yes.
Is your first name Josh?
It's Jared.
Jerry. Madi, I think it was page 3. Well, the only camera we see is not a Jerry, so
No, it's excuse me, it's Jared.
there we go. Mr. Roundtree, would you please raise your right hand? You swear or affirm under penalty of perjury that testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Spell your name, please.
Jared. Last name Rountree.
Thank you. And you've been admitted as an expert before this division?
Yes.
In what field?
Geology.
Okay, thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Roundtree, I'm looking at your exhibit. I believe it's page 168 of 197 of the application, rather than the exhibits, I guess, of the application. Oh, yeah. It looks like Ms. Vance has it in front of us. Do you see what Ms. Vance is sharing with us, Mr. Roundtree?
Yes, I do.
Okay. And you see where there's, well, 2 different upper confining layers identified on that log there?
Yes.
Have you provided within any of your exhibits the actual pics for the top and base of both of those upper confining layers?
No, I have not. Not the actual pics.
Okay. If I were to ask you to either provide a supplemental exhibit or else amend your statement to include those pics, do you understand what I'm asking for?
Yes. So the actual depth of the top and base of those layers.
Yeah, that's correct. The looks like it's the Avalon shell, and then maybe the Avalon lime or the top of the first bone spring.
Yes, I could provide that.
Okay, very good. Thank you, Mr. Roundtree. Mr. Hearing Examiner, I have no further questions for this case. I think it's just a matter of whether we plan to continue it for them to submit their amended exhibit packets.
And besides what Mr. McClure just asked for, Ms. Vance, what else are you submitting?
We're going to submit a gun barrel diagram, the exhibit A and B for the OCD order, and then we'll submit a 2-mile surface map. And now I've added exactly what Mr. McClure has requested. We can add that along.
And Mr. McClure, do you want to review those before we take this case under advisement?
I will want to review them. I would recommend that we continue, but
Right. Okay. Sounds good. That's what we'll do. So Ms. Vance, would you continue this? I don't know how long it's going to take for you to get this information together.
I think we can have, like I said, by the end of August. So I would just request that we're on the 9/11 for quick check-in.
Sure. And we'll put that right after your other case.
That sounds great. Thank you.
All right. Anything further?
No.
No, thank you. We're off the record here. Now we're on to FAE 2 operating. This is case number 20 in our docket, case number 25410.
Mr. Examiner Ernest L. Padilla for FAE operating.
Good morning. Any other parties that you know of?
Not that I know of.
Okay, why don't you go ahead?
Mr. Examiner, we have submitted a self-affirmed statement of Joseph Kent, who is a landman with FAE, and he has been the driver and the principal in obtaining the South Jowl statutory unit, which was approved by Order R 23736 on March 12th, 2025. The reason we're here today is to rescind a water flood within the South Jowl statutory unit. And that acreage consists of section 32, township 25 south, range 37 east. The South Jowl statutory unit order makes it optional as to whether to continue the Arnott Ramsey waterflood project in section 32. That was authorized by order number R-21423. The latest order on the statutory unit makes it optional as to whether that unit or the water flood should continue. If, and it makes it contingent on whether FAE, which is the operator of both the water flood and the statutory unit, continues to inject water into the water flood. They have now discontinued any further injection into the water flood project, and it's no longer needed. So that's the reason we're here. We're here to rescind order number R-21423. And it's pretty much a no-brainer on this thing because the water flood is no longer part of the statutory unit operation, or will not be. Now, Mr. Kent is standing by to answer any questions. I also have my own self-affirmed statement here, which is part of Exhibit B, where we have notified essentially 4 interest owners, including the State Land Office and the Bureau of Land Management, and 2 other working interest owners. One of them is Pilot Water Solutions. And I don't know what their role is. I suspect that they are probably supplying water or taking water from the water flood. But we've notified everybody, and I don't see any reason not to rescind the prior order allowing the water flood project. So with that, we move the admission of exhibit packets A with the self-affirmed statement of Mr. Kent and my own self-affirmed statement as to notice. And we ask that the case be taken under advisement.
All right. Thank you, Mr. Padilla. Without objection, is it Mr. Harris that is the technical examiner? Yes. Oh, Mr. Getz. Well, did you want to come on up here and ask some questions? No. Okay. All right, sounds good. Mr. Padilla, the case will be taken under advisement.
Thank you.
Let's take a 5-minute break and we'll be back on the record at 10:20. Now, case number 21 was not originally on this docket, 25220, but it is now. Entry of appearance, please.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of FAE2 Operating LLC.
Okay, and Ms. Hardy, the reason that I called this case was because the technical examiner who's reviewing this case, and it's quite an extensive evidentiary record, requests that you provide a new cover letter, because the cover letter that was provided references some exhibits that are not correct. And do you want to look at it for a moment so I can?
Sure. And Mr. Examiner, while they're reviewing, may I enter my appearance, please?
By all means.
Carrie Hatley, entering your appearance on behalf of ConocoPhillips Company.
Thank you, Ms. Hatley.
Mr. Examiner.
Yes, Mr.
Tony
Harris.
If I could, I've got the documents open. I can share my screen in the interest of time.
Perfect. Go right ahead.
Okay, thank you.
Thank you.
Can you see my screen?
Yes.
Okay. So this is in relation to case 25220, and you recall we had that hearing last week on July 29th. And so this was a notice of amended exhibits, and this was provided on August 1st, 2025. So there was two items that were requested. Number one was a plan of development, and it's listed here that exhibit A1 contains the supplemental plan of development. However, as we'll see here, if I go, so this is the package again for case 25220, and it starts with the self-affirmed statement of Mr. Joseph Kent, and it's 1,125 pages. So again, the notice of amended exhibits from August 1st refers to exhibit A1. However, the plan of development is actually on page 122 of 1125, and it's not exhibit A1, it's actually exhibit D. And again, that's on page 122 of 1125.
And Mr. Examiner, I can actually explain that exhibit D, there are multiple exhibits because the application is exhibit A1, but the application includes as an exhibit the unit agreement and its attachments. And this is one of the attachments to the unit agreement. So it is part of exhibit A1.
Because exhibit A1 starts back on page 7, I believe, yeah, of 1125.
Right, and I think if you scroll down, so exhibit
Then just bear with me for a moment, because if we go to
Okay.
page 465, this is also an exhibit A1.
I think that
related to a freshwater sample.
it's complicated, Mr. Examiner, because the C108 includes exhibits. And so I think that's what you're looking at right now. That's exhibit A1 to the C108. The C108 is an exhibit to our affidavit. So there are layers of exhibits, and that's the way that, yes. And I think Ms. McLean can share her screen if that's acceptable. I understand it's confusing due to the layers upon layers of exhibits.
Okay, while I've got this open, if I could just, I'll go back again to the August 1st submission, the amended exhibits. And here it references exhibit C6, which is for freshwater samples. I couldn't find an exhibit C6. The only thing I could find was exhibit B6, which go into the second document for this case, which is 420 pages, and on page 11 of 420. That's where exhibit B6 starts in relation to the water sample. And more specifically, page 20 of that document. This is the statement on the water sample. So this to me was very confusing.
And I'm sorry, you're correct. There was a typographical error on that. The notice should have said B6 for that supplemental water statement, which is where it is located in the record.
Yeah. And I guess just to avoid confusion, when we reference exhibit B6, just also reference the page number, stating that it starts on page 11 of 420. Because if we go to page 154, there's also an exhibit B, I believe. Oh no, sorry. If we go to page 154 of 1125, I believe that's also an exhibit B.
I believe that's an exhibit B to the unit agreement. So, Mr. Examiner, if you
Exhibit B.
look, yes, so that's
Ms. Hardy?
Yeah.
Do you think it's possible to redo the table of contents to this enormous document and lay it out with page numbers so that even if there are multiple Ds or As or whatever it may be, that there are page numbers so that Mr. Harris is clear, he knows where to go?
Absolutely.
Okay. Mr. Harris, is that acceptable?
Sure, that'll work.
Okay. Is there anything else?
Yeah, with the adjoining case, or the companion case, I guess, 25221, we also received amended exhibits. Again, this was received on August 1st. And in this particular case, it refers to exhibit C6, which again refers to the freshwater samples. But it's actually should be B6, which starts on page 168.
That's correct. We'll submit a table of contents that identifies the exhibits and sub-exhibits for each case.
With page numbers.
With page numbers, sure. You do
Yeah,
that.
the page numbers are important because, again, this is page 168. If we go to page 53 of 437, that's also an exhibit B6. So yeah, referencing the page numbers is important.
Sure, we'll be happy to do that.
Okay, thank you.
Thank you, and I'm sorry for the confusion. There are a lot of documents.
It's a huge document.
So, Mr. Harris, once you get this revised table of contents, can we take these two cases under advisement?
I'll have to see, because looking at the plan of development that was just received in what I was calling Exhibit D, it mentions some of the pressure support from water injection wells, and it refers to some SWD wells, if I'm not mistaken, that will be used, saltwater disposal wells that will be used for pressure maintenance. And so there may be some items there that need to be clarified. I need to review it first.
Okay, sounds good. So then, Ms. Hardy, will you continue these two cases to which docket, Mr. Harris? Would you like the September 11 docket?
That should work.
Ms. Hardy?
That's fine.
All right, thank you.
Mr. Hearing Examiner, may I just enter an appearance on behalf of Oxy? Sorry, we weren't listed on the worksheet, but we entered an appearance. Holland and Hart entered an appearance on behalf of Oxy in both cases.
Okay, thank you. Okay, so Ms. Hardy, anything else on these two cases before we move on?
No, thank you.
All right, very good. We're off the record, and you'll move these cases to September 11. Okay, let's go on to number 22. This is PBEX Operations 25303.
Good morning, Mr. Hearing Examiner Matthias Sayer from Bradfute Sayer on behalf of PBEX Operations LLC. And there are a number of parties who entered an appearance.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating and ConocoPhillips Company.
Thank you, Hatley.
Monitoring only.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewburn and MRC Permian, and we are just entering an appearance.
Okay, thank you.
I believe Avant had entered an appearance, but has subsequently withdrawn their appearance, their entry.
Good morning. Yes, Yaritza Pena on behalf of Avant Operating 2 LLC, but we have withdrawn our appearance in this case.
Perfect, thank you. And you had an objection, you said, and you've withdrawn it.
We had only entered our appearance in this case.
So there were no objections then?
No.
Was there an objection?
No, I just want to correct. It's MRC Delaware is who we entered an appearance for.
Thank you. Okay, Mr. Sayre?
Yeah, Mr. Examiner, the matter was contested. However, an agreement has been reached.
Okay. What party contested it?
Newborn.
Thank you. And who's representing Newborn?
Holland and Hart.
Oh, that's what I thought. Okay.
Yeah, but we have, sorry, I should have said that. We have since withdrawn our objection and we're just entering our appearance to preserve rights.
Thank you, Mr. Sayre.
Yeah, so Mr. Examiner, PBX seeks approval of an overlapping spacing unit as well as an order pooling a standard 642.79 plus or minus horizontal spacing unit in the Bone Springs formation. We filed a few amended exhibits on July 31st and previously filed a pre-hearing statement. We have a healthy collection of exhibits and affidavits that had been filed. Within there, we have affidavits from PBX's land person, geologist, facilities engineer, and reservoir engineer, as well as the standard notice exhibit. For what it's worth, to the extent there are questions, the PBX geologist has been recognized as an expert before the division. However, the geologists, facilities, and reservoir engineers have not previously testified before the division. So we would request this morning that the exhibits be entered, that the three experts who have not previously testified be recognized as experts, and that the matter be taken under advisement.
Okay. Your exhibits are admitted without objection. Your witnesses, if we need to put them under oath and question them, then we will qualify them individually. But if there's no need to do that, then we'll leave that for another day. You said one witness was recognized previously. That was the geologist.
That's the landman, Ms. Ruth Pelzo.
Oh, so of the three, the landman is the one who has been previously recognized.
Correct.
Okay. And the geologist, and who else has not?
Facilities and reservoir engineers.
Perfect. All right. Who is the technical examiner on this case?
Andy Fordyce here, Mr. Hearing Examiner.
Perfect. Thank you, Welcome, Mr. Fordyce. Mr. Fordyce, the exhibits have been admitted into evidence without objection. Are there any questions for any witnesses?
No questions for witnesses, but there is a correction to the compulsory pooling application checklist that is on page 13 of 143 of these exhibits. And it involves, I think there was a correction to a pool code. However, there are, and this spacing unit crosses two pools, but the pools are listed twice. Once in the grayed out formation pool section, and those are the correct pools for this case. And again, below, about 3 lines below that in the pool name and code, there's different pools, and those are not correct pools for this case. So we basically need to clean up the pools in this checklist.
And Mr. Fordyce, the checklist is what is referenced as Exhibit A in the order?
Correct.
All right. Are there any other changes you need made?
No, Mr. Hearing Examiner, that was the only one.
All right. So, Mr. Sayre, the way we do this is that needs to be corrected and then resubmitted. The case will have to be moved to another docket. Now, we do have a special docket next week on the 12th and the 13th. So if you continue this case to one of those days, we'll hear it as a preliminary matter in the beginning of our day.
Yeah, understood. We can do that.
All right, sounds good. Now, Mr. Fordyce, do you think you will need any of these witnesses to come back, or the witnesses are done for this case?
No, I shouldn't need to talk to any of the witnesses,
Perfect.
Mr. Hearing Examiner,
All right.
just this correction to the CPAC.
All right, perfect. All right, so Mr. Sayer, when do you think you can have this resubmitted?
Within 24 hours.
Okay, sounds good. All right, so once you do that, would you attach a cover letter to the revised exhibit packet, explain what you've corrected, and then we'll see this on the 12th or 13th. I don't care what day it is.
Yeah, very well.
Is there
Thanks,
anything
sir.
else?
No, thank
All
you.
right, we're off the record in this case. Thank you.
Mr.
Okay, yes.
Since Mr. Fordyce is now starting his
Yes.
cases, may I?
Yes, number 40?
Yes.
Mr. Fordyce, can we hear number 40 now?
Yes, sir. That would be fine, Mr. Hearing Examiner.
Okay, I'm going to call this case out of order. It is 25482 Oxy USA.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Oxy USA Inc. And I don't believe there are any other parties in this
Please
case.
proceed.
So in case number 25482, Oxy is seeking to pool and also for approval of a non-standard spacing unit. And the non-standard spacing unit is to accommodate the U-turn wells that are proposed in this case. The pooling, the acreage is a non-standard 655.31 acre, more or less horizontal well spacing unit. And that is comprised of all of irregular Section 6, Township 22 South, Range 32 East, and that's Lee County, New Mexico. And Oxy seeks, Oxy seeks to initially dedicate this spacing unit to the Party Trap Federal Com 31H, 32H, and 33H. We have included a copy of the application, the compulsory pooling checklist, as well as the self-affirmed statements of landman Courtney Carr and geologist Seth Brazel, both of whom have previously testified before the division. We have included all the standard exhibits required for both land and geology. In addition, with the land, we've included the NSP tract map and notice list. Then we have my self-affirmed statement of notice with a sample copy of the notice that was timely mailed out on July 18th, 2025, and the affidavit of notice of publication that was timely published on July 18th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that the case be taken under advisement at this time.
Thank you, Ms. Vance. Without objection, Mr. Fordyce?
I have a question for the geologist.
Okay, very good.
Great.
Would you call your geologist?
Mr. Brazel should be on the line.
Yes, good morning.
Mr. Brazel?
Yes, I'm here.
Okay, great.
Hold on. Hold on. There we go. Okay. All right. So would you raise your right hand? Do you swear or affirm under penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Spell your name, please.
Seth, S-E-T-H, last name Brazel, B-R-A-Z-E-L-L.
And have you been qualified as an expert before this division?
Yes, I have.
In what field?
Petroleum geology.
Okay. Mr. Fordyce?
Yes, been having some weird internet connections this morning, so bear with me if I fade in and out. But Mr. Brazel, I was just curious. I'm looking at Exhibit D1 on page 32 of 41, and I was just curious. First of all, does Oxy plan on just completing and stimulating just the north-south portion of these wells, or the whole entire length?
Yeah, that's a good question. So typically we will complete everything that is not parallel with SH Max. So it will be some of the turn, but not all of the turn.
Okay. Yeah, I was just curious what how Oxy planned to attack this and what discussions had been had, because on the Exhibit D3, the structural cross-section for the X, Y, and A, I see that it can be quite thin in places, 100 feet or so. And in Exhibit D1, there's obviously portions that overlap. So just out of curiosity, I was wondering what, I'm sure you've had, there's a plan for anti-collision, but more specifically, I was wondering about interference, during the stimulation, or, like you said, maybe some portions wouldn't be completed. So that was just what I was wondering. Maybe you could expand on that for me a little bit.
Yes, sir. So we do try and minimize overstimulating intervals, especially as those wells in the portion where they turn 180 degrees. And so we typically do not stimulate the entire portion of the U-turn, but we will stimulate those portions that are not directly overlapping with an adjacent well. And also we minimize the number of stages that are in the turn that are tangential to SH max. Typically, we complete a number of 40 stages through here with a regular stage spacing of approximately 250 feet.
Okay, very good. So I just understand then that obviously you don't just go into this blindly, and there's a strategy and a plan, and something has been thought out. So I appreciate that, Mr. Brazell. I don't have any further questions.
Yes, sir. Thank you.
Mr. Fordyce, are you finished with your questions for all the witnesses?
Yes, Mr. Hearing Examiner, I am.
Okay, may this case be taken under advisement?
Yes, sir, it can.
All right, thank you.
Thank you.
All right, going back to our regular docket order. We are on number 23. This is Taprock 25315.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak, appearing on behalf of Taprock Operating.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart. And we're actually representing COG and Concho in this case, not Oxy.
Did you object?
No, we just entered an appearance. I think that's right now we're just preserving rights.
Okay. Mr. Suazo, are there any other parties that you know of?
No, Mr. Examiner.
Okay, please proceed.
Sure. And just as a reminder, the application was amended on May 5th to provide a correction to the legal description in the notice documents. And that's why this was pushed to the current date to reflect those updates to the mineral interest owner developments. So in this case, Taprock is requesting an application to approve a standard horizontal spacing unit consisting of 1,280 acres, more or less, in the west half of section 17 and 20, township 26 south, range 26 east, and the east half of sections 18, east half of section 18 and 19, township 26, range 26 east in Eddy County, New Mexico. There's 4 wells in this spacing unit, the Coors Vedicom 211H through 214H, and those are going to produce from the Purple Sage Wolfcamp Formation. The exhibit packet was filed on July 31st and contains the standard suite of applications, affidavits, and exhibits. Exhibit A is the compulsory pooling administrative checklist. The amended application filed on the 31st of July is the proposed notice of hearing, and that was filed on May 13th. Exhibit C is the affidavit of senior landman Erica Shoemaker, who has previously testified before the division, and her qualifications have been accepted and made a matter of record. Exhibit C 1 through 6 are the standard suite of land exhibits. Exhibit D is the affidavit of senior geologist Eli Denbeston, who has also previously testified before the division, and his qualifications have been accepted and made a matter of record. He also has exhibits D1 through D5, which are the standard suite of geology exhibits. And finally, Exhibit E is the notice affidavit showing that notice letters were mailed on May 13th and again on July 16th to the addresses of record of the interested parties. There's mailing receipts attached with proof of publication in the Carlsbad Current Argus. And with that, I'd like to request that the exhibits be admitted into the record and these matters be taken under advisement unless there are any questions.
Thank you, Mr. Suazo. The exhibits are admitted without objection. Let's go to Mr. Fordyce.
I don't have any questions for this case, Mr. Hearing Examiner.
Great, thank you. This case is taken under advisement.
Thank you.
Okay. Let's move on to number 24. This is Chevron USA 25432.
Good morning, Mr. Examiner. Dina Bennett on behalf of Chevron in case 25432. And there are no other parties to my knowledge that have entered an appearance.
Thank you, Ms. Bennett. Please proceed.
Thank you. In this case, Chevron seeks an order pooling uncommitted mineral interest owners in the west half of section 16 and 21, township 25 south, range 27 east, Eddy County. And in the materials, I've included the usual suite of exhibits, including an affidavit from Chevron's landman, who's previously testified before the division and whose credentials have been accepted as a matter of record, as well as exhibits from the geologist, who's also previously testified before the division and whose credentials have been accepted as a matter of record. This is in the Purple Sage Wolf Camp, and just a couple of, well, before I move on to some discussion points on the exhibits, I'd ask that the exhibits in this case be accepted into the record.
Thank you. Without objection.
Thank you. So two things to point out in the compulsory pooling checklist. First, there is a depth severance in this acreage, and the depth severance is discussed in the compulsory pooling checklist, as well as in Katie Halley's declaration at paragraph 14. And so she describes the depth severance and also describes that notice was given to the owners above and below the depth severance. And then the other item I wanted to point out is an item I identified in red in the compulsory pooling checklist, which is that one of the wells, the 465H well, if you were to just look at its location, it would seem like it's non-standard based on the Purple Sage Wolf Camp setbacks, which require 330. Well, actually, that's true for anything for the completed lateral, except for gas. I digress. The main point being that this is an irregular section or irregular sections. And so although it looks like the well's completed lateral is closer than 330 to the outer boundary, it is actually at its closest point, it is 330. So it's 330 or more from the outer boundary because of the nature of the irregular sections. So those are the only 2 points I wanted to make to try to address any questions up front that the division may have based on the checklist and the materials.
Thank you, Ms. Bennett. Let's go to Mr. Fordyce.
Yes, I've reviewed this case and all of those details, and I don't have any questions for this case.
Okay, this case will be taken under advisement. Thank you.
Thank you very much.
Moving on to number 25 on the docket. This is Coterra Energy 25439.
Thank you, Mr. Examiner. Dina Bennett on behalf of Coterra Energy. And I actually intended to dismiss this case, and it just fell off my radar. So I'll file a dismissal today.
Okay, excellent. Thank you.
Thank
We're
you.
off the record in that case. Moving on to number 26, 25444. This is Spur Energy.
Yes, Jackie McLean on behalf of Spur Energy Partners.
And Carrie Hatley entering an appearance on behalf of ConocoPhillips Company.
Thank you.
Thank you. In case number 25444, Spur seeks an order pulling all uncommitted interests in the San Andres Formation, underlying a 160-acre, more or less, standard horizontal spacing unit comprised of the north half, south half of Section 36, Township 17 South, Range 27 East in Eddy County, and will dedicate this unit to the Cactus Sour State Com 110H well. The exhibits were timely submitted for this case and include land testimony and corresponding exhibits of Colleen Bradley, who has been previously admitted to testify, as well as geology testimony and exhibits from Matthew Van Wee, who has also been previously admitted to testify as an expert geologist. Finally, we include my notice testimony along with copies of the notice letter, which was sent to all interested parties on June 18th, 2025, electronic return receipts, and the affidavit of publication for June 21st, 2025. With that, I ask that the exhibits be admitted for case number 25444 and that the case be taken under advisement.
Thank you. Your exhibits are admitted without objection. Mr. Fordyce.
I don't have any questions for this case either, Mr. Hearing Examiner.
Thank you. This case is taken under advisement. Let's move on to another Spur Energy case, 25445.
That would be me, Jackie McLean, on behalf of Spur Energy Partners. And I don't believe there are any appearances. In this case, Spur seeks an order pulling all uncommitted interest in the San Andreas Formation underlying 160-acre standard horizontal spacing unit comprised of the south half of Section 36, Township 17 South, Range 27 East in Eddy County. And the unit will be dedicated to the Dark Frost State Com 110H well. Exhibits again are from Colleen Bradley and Matthew Van Wee. And the notice, exhibits, and testimony show that notice was sent to all interested parties on June 18th and affidavit of publication for June 21st, 2025. And unless there are questions, I ask the exhibits be admitted for case number 25445 and that the case be taken under advisement.
Thank you. Your exhibits are admitted without objection. Mr. Fordyce?
No questions, Mr. Hearing Examiner.
All right, thank you. This case is taken under advisement. Let's cut to the chase. It looks like there's two other Spur Energy cases as well, 25445 and 25452. Are they both yours, Ms. McLean?
Yes, and you just heard 25445. We just have 25452 left.
Hard to say. Yes, go ahead.
Okay, thank you. Yes, this is Taylor Crest, and Spur seeks an order pulling all uncommitted interest in the San Andreas Formation in the south half, north half of Section 25, Township 17 South, Range 27 East in Eddy County, and it will dedicate this unit to the Taylor Crest B Federal Com 110H well. Again, we have exhibits and testimony from Colleen Bradley and Matthew Van Wee. And again, notice was sent out June 18th and that publication ran June 21st, 2025. So I ask that the exhibits be admitted for case number 25452 and the case be taken under advisement.
Thank you. Your exhibits are admitted without objection. Mr. Fordyce?
This case can be taken under advisement.
Another
Thank
home
you.
run. All right.
Thank you.
So now we move on to number 29. It looks like we have a few cases here, XTO Energy cases, 254, 56, 57, 58, and 59. They're all joined.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant XTO Energy Inc. And I don't believe there are any other parties included who have entered an appearance in this case.
Do you want to present them as a group?
I would.
Please.
Okay. So in these cases, we're just pooling the record title owner for purposes of getting the federal CA approved. I will note that neither our landman or geologist has previously testified before the division. So we did include copies of their resumes and I think so they are available to be admitted and answer questions. With regard to all of these cases, the acreage is all within Township 25 South, Range 29 East, and that's in Eddy County, New Mexico. So in case number 25456, XTO is pooling the uncommitted interests in a standard 960 acre, more or less, horizontal well spacing unit, and that is comprised of the west half of sections 22, 27, and 34. And the pool there is the Willow Lake Bone Spring Southeast, and the pool code is 96217. And dedicating that to the Corral 22 TAC 34 FedCom 205, 307, 102, 104, and 207H. And I will note that the 207H is the proximity well allowing for the enlarged spacing unit. Following that, we have case number 25457, and XTO is pooling the uncommitted interest in a standard 960 acre, more or less, horizontal well spacing unit. And that is comprised of the east half of sections 22, 27, and 34. The pool there is, again, the Willow Lake Bone Spring Southeast pool, and the pool code is 96217. And dedicating that spacing unit to the initial Corral 22 TAC 34 FedCom 303, 407, and 402H. And I will note that the 407H is the proximity well allowing for the enlarged spacing unit. Next, we have case number 25458. An XTO is pulling the uncommitted interest in a 320-acre, more or less, horizontal well spacing unit, and that is comprised of the east half of sections 22 and 27. Again, same pool, Willow Lake, Bone Spring Southeast, and the pool code is 96217. And that spacing unit is initially dedicated, or XTO is initially dedicating that unit to the Corral 22 TAC 34 FedCom 405H. And then lastly is case number 25459. And that is XTO is seeking to pool the uncommitted interest in a standard 1,920 acre, more or less, horizontal well spacing unit. And that is comprised of all of sections 22, 27, and 34. And that is within the pool there is the Wolf Camp Bones Purple Sage, and the pool code is 98220. And there are a whole bunch of wells here. I'm not going to list them out, but I will note that they all are at a non-standard location. I believe it's the first take point, if I'm not mistaken. I did all the NSLs and I have filed them separately through the administrative process. And I will also add that the 203H is the proximity well allowing for the enlarged spacing unit. Again, neither of our experts have previously testified, but we have included their resume along with all of the required land and geology exhibits. And then following that is my self-affirmed statement of notice with a sample copy of the letter that went out and was timely on June 20th, 2025. And then following that is the affidavit of notice of publication that was timely published on June 24th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Thank you. The exhibits are admitted without objection. Mr. Fordyce?
Mr. Hearing Examiner, we need to have some corrections to case number 25458. And the corrections involve basically everywhere where the bottom hole location and last take point are referenced in this case. For example, the application checklist on page 4, the application itself, pages 6 and 8, the landman statement, page 9, and so on and so forth. It states that the bottom hole location is in section 34. However, this spacing unit only covers sections 22 and 27. So we'll have to get that corrected. Some of the other cases went, I think all the other cases went through 34, but this one did not. So it's just a correction that needs to get cleaned up.
Understood. That's an easy correction for us to make, and I apologize.
Are there any questions for any of the witnesses, Mr. Fordyce?
No questions for witnesses, Mr. Hearing Examiner.
All right. Once these corrections are made, are you going to want to review the case further, or can we take it under advisement?
As long as all of the references for the bottom hole and last take point are corrected to reference section 27, it should be good to take under advisement.
So there's only one case that needs revising. The other three we can take under advisement now. Is that right?
That is correct.
All right. So Ms. Vance, the other three cases are taken under advisement.
I can complete this today and get it across to Mr. Fordyce if that would work for him. It doesn't sound like we need to come back, and if that's possible, it's a pretty straightforward correction, and I'd appreciate to just get it done today and to the examiner.
Okay. Yeah, I think we can call this a typo in this case. So Mr. Fordyce, Ms. Vance is going to correct this by the end of the day and file a amended exhibit packet with a cover letter explaining what she's corrected. Will you have a chance to look at that? If you find a problem with that, would you let me know, and we'll let her know that she has to come back?
Yeah, that's fine, Mr. Hearing Examiner.
All right, sounds good. All right, we're off the record in these four cases then.
Thank you.
Let's move on to number 33 and number 34. This is WPX Energy.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Aberdeen Shill. Appearing on behalf of the applicant, WPX Energy Permian LLC, and I believe there's one other party who's made
Yeah,
an
Mr.
appearance.
Examiner, good morning. Carrie Hatley entering her appearance on behalf of Marathon Oil Permian.
In one case only, right?
In one case only, yeah,
Sounds good.
25468.
And are there any objections?
No.
No. Mr. Savage?
Yes. Cases 25467 and 25468 cover lands in the east half, sections 23, 26, and 35 in Township 26 South, Range 30 East, Eddy County, New Mexico. WPX has one witness today in these cases. It's landman Tim Prout, who has testified previously before the division, and his credentials have been accepted as an expert witness in petroleum land matters. The applications in these two cases are submitted seeking to pool additional working interests discovered in previously pooled units after the original pooling hearings were held on March 13th, 2025. WPX had received pooling order number R23780 that pooled uncommitted interests in the Bone Spring underlying the east half of sections 23, 26, and 35, and WPX received pooling order R-23781 that pooled uncommitted interest in the Wolf Camp underlying the subject lands. WPX discovered additional unpooled interest in the two units and seeks to pool the interest under the terms of the two pooling orders. In case number 25467, Mr. Prout provides his Exhibit A, a copy of the order 23780, pooling the Bone Spring, an ownership breakdown of the unit that includes the newly discovered interests and owner, and the well-proposed letter sent to the owner, and the chronology of contacts with the owner of the additional interests. In case 25468, Mr. Prout's Exhibit A includes the same types of exhibits, but as they relate to pooling the interests under the terms of order number R-23781 for the Wolf Camp underlying the subject lands. Exhibit B in cases 25467 and 25468 provide the self-affirmed statement of notice for mailings and publication notice. Notice by letter was timely mailed on July 17th, 2025, and notice was timely published on July 19th, 2025. Mr. Hearing Examiner, at this time, I move that Exhibits A and B and all sub-exhibits be admitted into the record for these two cases and that the cases be taken under advisement. Witness and counsel are available for questions.
Thank you. The exhibits in both cases are admitted without objection. Mr. Fordyce, questions?
I don't have any questions for these cases, Mr. Hearing Examiner.
Thank you. Both cases are taken under advisement.
Thank you.
Moving now to COG operating. We have two cases at number 35 and 36 on the docket, 25476 and 77.
Thank you, Mr. Hearing Examiner. This is Ann Tripp on behalf of COG Operating LLC. Case matters 25476 and 25477. I don't believe that any parties have entered their appearance.
Perfect. Please proceed.
Thank you, Mr. Hearing Examiner. So in case 25476, COG Operating seeks to pool all non-ratifying overriding royalty interests in the owners in the Wolf Camp Formation, Purple Sage Wolf Camp Pool, in a standard spacing unit of 640 acres, comprised of the east half of sections 6 and 7 in Township 26 South, Range 29 East, located in Eddy County, New Mexico. This spacing unit of 640 acres will be dedicated to the Pudge Federal Com 701 through 704 wells and 901 through 904 wells, with 702H as the defining proximity well. With the application for compulsory pooling, we've submitted exhibits A, A1 through A7, B, B1 through B4, and C, C1 through C4, covering land testimony, tract ownership, geology, and notice. With me today, land representative for COG is Mr. Jeffrey Stout, and geologist Ms. Jessica Poniff. Both have previously testified before the division, and their credentials have been accepted as a matter of record in the areas of petroleum land management and geology, respectively. In case 25477, COG seeks to pool all of the non-ratifying overriding royalty interest owners in the Bone Spring Formation of the east half of section 6 and 7. The difference in this application is that we're also requesting approval of an overlapping spacing unit. The 640 acres in the east half of section 7 will overlap with a prior spacing unit established for the Pudge Federal 21, and this is described in the land affidavit. The owners in that previous spacing unit are also identified in Exhibit A4A, I believe. The same witnesses are here with me, Mr. Stout and Ms. Pontiff for land and geology. And with that, we would ask that both these cases be taken under advisement and the exhibits and sub-exhibits admitted to the record.
Thank you, Ms. Tripp. The exhibits are admitted without objection. Mr. Fordyce?
So in case 25476, the compulsory pooling application checklist describes 6 wells. However, the application itself on page 5 has a 7th well, the 703H, that is not included in the CPAC. Also, the land statement on page 10 includes a 7th well. There are a C102 for this 703H, the 7th well. The geology exhibits starting on page 30 do not contain this 7th well, the 703H. In addition to that, there is an error just in the checklist describing the building blocks as quarter, but that is not true for this Purple Sage Wolfcamp pool. So I'd like to see a correction to the building blocks and some resolution proposed to identify whether this case is for 6 wells or for 7 wells.
Yes, that's an omission on our part. It should be for 7 wells. 703H is included, and that line was not added in the application in the CPAC Exhibit A. So we will amend and correct that, as well as submit an amended and corrected geology exhibit to identify the 703H. Our geologist is here if you have any questions for her, if it would affect any part of the pooling.
I don't have questions. It's just a matter of making sure that if there's 6 wells, we talk about 6 wells throughout the exhibits, and if there's 7 wells, let's talk about 7 wells throughout the exhibits. Is where I'm going with that, really.
Yes, sir. We can fix that and submit that before the end of the day today.
Okay, so that's going to need further review, Ms. Tripp. So what I'd like you to do is submit an amended exhibit packet with a cover letter explaining your changes to the CPAC and this land statement or the geology exhibit, whatever is going to be fixed, and then move these. Is it just one case, Mr. Fordyce, or both cases have the problem?
That is the problem for 25476, and there is an error in the CPAC also in case 25477.
Would you like to tell Ms. Tripp what the problem is?
Yeah, on page 2, let me see my notes. In the formation pool section, the pool name and code is incomplete. It just says Bone Spring South. That is the Red Bluff semicolon Bone Spring, South 51010. So that pool name in the checklist is incomplete.
Yes, sir. That's I'm looking at the hearing exhibits that were submitted, and it identifies pool name and pool code Bone Spring South 51010. It should be Red Bluff Bone Spring.
Yes, that's correct. Red Bluff semicolon, then Bone Spring, South, and the rest is correct. The pool code is correct. Just a portion is missing.
So we'll correct the Exhibit A in case 25477 for pool name and pool code.
Mr. Fordyce, is that the extent of the corrections?
That is the extent of the corrections, Mr.
All right. So, Ms. Tripp, the reviewer needs an additional time to review the corrected exhibits once you refile them. So I'm trying to think if we have any other docket before September 11 for you to move these two. Mata E, I know we have the ones on the 12th and 13th. Is there anything after that?
One minute.
We have a status conference on the 21st.
Okay, and typically we don't have a technical reviewer on the 21st, so I don't want to burden Mr. Fordyce with that. And is that the next, after that is the 11th of September?
Correct, that's the next one.
So we have no others in August, okay. And Mr. Fordyce, are you participating in the cases on the 12th and 13th?
Yes, sir, I believe I am.
Okay, so Ms. Tripp, can you get these changes made and have a amended exhibit packet for both cases with cover letters by tomorrow close of business?
Yes, Mr. Hearing Examiner, we can do that.
All right, if you can do that, then you'll move these cases to the 12th. I don't know what day we'll hear them. It may be the 12th, it may be the 13th, but it's be at Mr. Fordyce's convenience.
Thank you, we can do that. And will the witnesses need to be available?
I don't know, Mr. Fordyce?
I don't believe I would have any questions for the witnesses. It's just a matter of correcting the exhibits, I believe.
Understand.
Thank you.
Thank you.
Thank you. Let's take a 5-minute break. We'll come back on the record at, let's see, it's 11:17. Oh, about 11:22 or so. Thank you. We are moving on now to number 37 on the docket. This is Marathon Oil Company. And your appearance, please.
Ann Tripp on behalf of Marathon Oil Permian LLC in case number 25478. And I don't believe any other parties have entered an appearance.
Perfect. Please proceed.
And thank you, Mr. Hearing Examiner. So Marathon Oil Permian has applied to pool all non-committed or non-ratifying overriding royalty interest owners and record title interest owners in a non-standard spacing unit of 600 and 38.4 acres, I believe it is. That's comprising the east half of sections 6 and 7 in Township 26 South, Range 29 East. This application was amended July 18th of 2025 to include a working interest owner that had not voluntarily joined at that point, Oxy. In the space of time between the filing the hearing exhibits last week and this morning's hearing, Oxy has executed a joint operating agreement with Marathon for the Vaughn Wells and Spacing Unit. So Marathon no longer seeks to pool or request approval of drilling or operation costs or risk penalty. The spacing unit for this application will be dedicated to the Rick Vaughn Federal Comp 501 and 503H wells with, I believe it's the 501 as the defining well. It's a non-standard spacing unit application because of the location of the well path within the east half of section 6 and 7, not being within 330 feet to capture the additional quarter sections and the Bone Spring. And so the parties are identified, the offset or affected interest owners are identified in Exhibit A4A, and they've received notice as well. With the application and amended application, we've submitted Exhibits A, B, and C and sub-exhibits, and Mr. Stout for land and Ms. Pontiff for geology are here with me today to testify. They've both previously testified before the division, and their credentials have been accepted in the areas of petroleum land management and geology. So I would ask that the exhibits and sub-exhibits be accepted into the record and that this case be taken under advisement.
Thank you. Without objection, Mr. Fordyce.
I have questions for the landman, Mr. Hearing Examiner.
Okay, let's get just the landman, right, Mr. Fordyce?
Correct.
Thank you.
Hello. Can you hear me?
Yes, we can. Would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please spell your name.
Jeff, Jeff, last name Stout, Stout.
And you have been recognized as an expert by this division?
Yes, sir.
In what field?
Land.
Thank you. Mr. Fordyce?
Mr. Stout, I'm looking at Exhibit A5, which is page 22 of 110.
Yes.
Is Marathon seeking to pool Oxy Y1 company?
They amended our JOA, so there's no need at this point. And that happened just very recently.
Okay, how about Contango Resources?
Contango Resources, they are the record title owners, and they have signed signed the CA. Contango, but they did not sign for their override, which is a different entity, so they are being force pooled.
Okay. So I think I would like to request that we get a revised exhibit that shows in the recapitulation basically a format with the interest owner, their own what type and percent of interest they have, and then highlighting the parties that you seek to be pooled in yellow so that it's very clear who the division is, who you're asking the division to pool and who you're not asking to pool.
Okay.
Because it doesn't seem totally clear here. Also, I was curious in your descriptions of the land in exhibits A4A and here in exhibit A5. I think there's a minor correction maybe there to tract 1 that says tract 1 is section 6, lots 1 through 4. But tract 1 does not include lot 3. So that is a minor correction that maybe we could make.
Okay. I will certainly look at that and get it corrected.
Okay. That'll be all.
Thank you. Is that something you're going to want to review after it's been provided?
Yeah, I think I would like to make sure that
okay,
we understand who's being pulled and not, and what their interest is, and what type of interest, and have that in a more standard format.
Okay. Ms. Tripp, how long will it take for you to provide that?
I believe we can do that before the end of the week, as with the other cases.
Okay, sounds good. So then you can continue this case to the 8, 12, or 13 docket for Mr. Fordyce's additional review. Please provide a cover letter with the amended exhibit packet explaining what change you've made.
Yes, we will do that. Thank you.
All right, we're off the record in that case. Let's move on to number 38, 25479.
Good morning,
Powder
Mr. Hearing Examiner and Mr. Technical Examiner Ben Holiday with Holiday Energy Law Group on behalf of the applicant, Powderhorn Operating.
Thank you. Ms. Kessler? Mr. Holiday, what was Ms. Kessler's position when she entered an appearance?
They were monitoring only. They did not have an objection.
All right, why don't you go ahead?
Sure, yes, sir. Okay, so thank you, Mr. Examiner. In this case, Powderhorn seeks approval of a 640-acre non-standard horizontal spacing unit that's comprised of section 21 and 19 South, 27 East, Eddy County, and limited to the Bone Spring Formation. So this unit is going to be dedicated to the fadeaway 21 FedCom 301 through 304H wells. Now, we did file an amended exhibit packet yesterday afternoon. It had the standard detailed cover letter detailing the changes that we made, but just briefly for the record, we moved the risk penalty down from 300 to 200% where it should have been. We removed several parties from the pooling list, all listed in the cover letter. Those constituted about 0.8% of the working interest. And then we changed some of the titles on B4, just the heading titles. So in these exhibits, we provided the affidavits of landman Mason Maxwell and our geologist Leonard Wood. Both have previously been qualified as experts and have testified before the division. So Mr. Maxwell's exhibits provide the standard land exhibits as shown in our table of contents, being exhibits A1 through A8. Likewise, Mr. Woods provides the standard geology exhibits being B1 through B5. Finally, exhibit C, those are my legal exhibits, includes my notice affidavit and all the associated attachments. Notice in this case was timely sent on July 10th, 2025 by certified mail. And we also timely published in Eddy County in the Carlsbad Current Argus on July 17th, 2025. So with that, unless there are any questions, I request that the exhibits be admitted and this case be taken under advisement.
Thank you. Your exhibits are admitted without objection. Mr. Fordyce?
No questions for this case, Mr. Hearing Examiner.
Thank you, Mr. Holliday. It's taken under advisement.
Thank you.
Moving on to case 39 on our docket, 25481, Devon Energy.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Devon Energy Production Company, LP.
And I believe Ms. Kessler entered an appearance. Do you know what her position was?
I believe they were just preserving rights.
Okay, please proceed.
Thank you. So in this case, Devon is seeking approval for an overlap, a non-standard spacing unit, and pooling authority. So in this case, Devon is seeking to pool a non-standard 1,920 acre, more or less horizontal well spacing unit, and that is comprised of all of sections 17, 20, and 29, Township 20 South, Range 33 East, and that's in Lee County, New Mexico. And it is a Bone Spring pool. The pool is the Salt Lake Bone Spring, and the pool code is 53560. And Devon seeks to initially dedicate this spacing unit to the Sherman 29 TAC 11 FedCom 111H, and actually a whole bunch of other wells, and I'll save the time of the division. It's in the application and hearing packet. In this case, we've provided a copy of the application along with the compulsory pooling checklist. And then the statements of landman Aaron Young, who has previously testified before the division, and then our geologist, Joshua O'Brien, who has also previously testified before the division. Along with their statements are all of the required sub-exhibits. I'll note that Mr. Young has also included a overlap track map to show the existing spacing unit in relation to the proposed spacing unit, along with the NSP, the non-standard spacing unit tract map and notice list. And then that is all followed by my self-affirmed statement of notice and a sample letter that was timely mailed on July 18th, 2025. And then lastly is the affidavit of notice of publication that was timely published on July 18th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that this case be taken under advisement at this time.
The exhibits are admitted without objection. Mr. Fordyce?
No questions for this case, Mr. Hearing Examiner?
And the case is taken under advisement. Thank you. Let's move to cases 41 through, I think, 45. These are Alpha Energy Partners, case numbers 254, 95, 96, 97, and 98. Entries, please.
Good morning, Mr. Hearing Examiner. Good morning, Technical Examiner Darren Savage with Aberdeen Shield, appearing on behalf of Alpha Energy Partners 2, LLC.
Thank you.
Good morning, everyone. Dina Bennett from Model Sperling, appearing on behalf of the City of Carlsbad. And we are not objecting to the cases. I've entered an appearance to preserve the city's rights.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of ConocoPhillips Company.
Thank you.
Mr. Examiner, Jacob Everhart with Betty Wozniak, New Mexico, on behalf of Coterra Energy Operating. For monitoring purposes only, we are not objecting.
Thank you.
Good morning, Mr. Examiner. Jonathan Samaniego, representing American Energy Resources.
Mr. Examiner, this is Dina Bennett again. I also entered an appearance on behalf of Magnum Hunter, which is a subsidiary of Coterra. And I'm not sure. I'll confirm with Coterra and Mr. Everhart, and I might be withdrawing my appearance on behalf of Magnum Hunter, but for now I'd like to leave it in just till I can get that cleared up with Mr. Everhart and with Coterra.
Okay, and do we have Mr. Anderson with us? Mada E, do you know if Warren Anderson is online?
Mr. Hearing Examiner, I know he was trying to get in the meeting this morning. I was with him on the phone. I don't know if he's here as of now.
Okay. Well, he knew about the hearing. We have a motion hearing to start this with. I did not receive a response from Mr. Anderson. The motion requests that I strike the entry of appearance in 3 of the 4 cases. I'm going to grant that based on the evidence that has been provided. I'm going to grant that. In the proposed order that was sent over by your office, Mr. Savage, you're also asking me to strike his appearance from the 4th case. I'm not willing to do that.
No.
So
if I could clarify, Mr. Hearing Examiner, I didn't ask to strike his appearance. It was overrule the objection, and I can explain the basis for the overruling of the objection.
In the 4th case?
In the 4th case, that's the
96.
That's 96. That's correct.
Well, I prepared an order granting the motion to strike the entry of appearance because of no ownership interest in 95, 97, and 98.
And we concur with that.
Right. And
but we agree that Mr. Anderson has a right to have an appearance in 96.
Right.
The question the question that really needs to be addressed is the basis of the objection, and that is whether Alpha, in looking at his objection, is whether Alpha has satisfied its obligation to make efforts to reach a voluntary agreement. And we believe that Mr. John Kaufman is available as a witness. He's a landman for Alpha. He can elaborate upon this. We believe that Alpha has more than satisfied that obligation to reach a voluntary agreement. Mr. Anderson, they own a very, very small interest. It's like 0.086% in the unit.
Hello?
0.275482 net acres. So we're really not talking about any kind of.
Okay, Mr. Anderson, is this Mr. Anderson?
Yes, I've been in this in the hearing since 9 o'clock. But
Mr. Anderson,
I can't.
Mr. Anderson, if someone's speaking, please don't interrupt them. I'll come back to you.
Yes, sir. Yes, sir.
But I'm glad you're with us. Okay, so keep going, Mr. Savage.
So,
but basically, Mr. Savage, let's cut to the chase. Is there something in the rule that allows me to strike an objection because good faith, in your idea, good faith negotiations have not been ongoing?
Well, I guess the question is, if Alpha has satisfied the effort to reach a voluntary agreement, then there is no basis for the objection. And then why would we have a contested hearing if there's no basis?
What I do know is that there's been an objection that's been entered, and unless you give me a legal basis to, as you say, strike the objection, you admit that he has an ownership interest. The contention is that he's not negotiating in good faith with you.
So when a party makes an objection, let's say in the contested hearing, they have to give a basis for that objection, and then the objection is either overruled or it's sustained.
I haven't experienced that. I have not.
That would be an analogy to what we were requesting, and in this case is that we don't see why the division would waste administrative resources hiring a court reporter and setting up time to hear an issue that could be settled right now.
Okay, Mr. Anderson, you're with us now. Do you want to enter an appearance in case number 96?
I wanted to enter. I heard, but I couldn't get through. But I was objecting to all 4 cases because I'm listed in all 4 cases.
Mr. Anderson, did you happen to get the motion that Mr. Savage filed yesterday and the email from Ms. Corral that gave you a 5 o'clock deadline to respond?
Yes, I got it.
Okay, so the contention, Mr. Anderson, is that you don't actually own an interest, a working interest in 3 of the 4 cases.
Right.
Okay, so if you agree with that, then I'm going to strike your entry of appearance in 3 of the cases, but I am so far maintaining your objection in case 25496. Now, the argument for Mr. Savage is that you have not been negotiating in good faith and that I should strike your objection, but I'm not hearing a legal basis to do that. And without a legal basis or some authority, Mr. Savage, to do that, then I'm going to leave the objection in place for now. And you can present the other 3 cases by affidavit today. And if you want to file a motion that presents and that gives me some a legal argument based on facts, then I'm willing to entertain it as long as Mr. Anderson has an opportunity to respond to that. Mr. Anderson, do you know how to follow this case 25496 in the online imaging system?
Sir, I do not.
Okay, so Ms. Corral, would you send Mr. Anderson a link by email later today? It's not necessary now, so that he can look at the documents that are filed in this case that he maintains an objection in, because it's already been stipulated that he has an ownership interest, however small it may be, in 25496. He has the right to object. And until Mr. Savage explains to me why I'm able to override that objection, then we're going to maintain that objection in this case. So, Mr. Anderson, what's happening here today is that there was a motion filed to remove your entry of appearance in 3 cases, which I've granted because you don't have an ownership interest in those 3 cases. Okay. And you understand that, right?
Yes. Can I ask one question, sir?
In just a moment. Let me just finish. Let me just finish giving you the summary, since I'm trying to give it to you in plain language as opposed to legal language. Okay.
Yeah.
However, it is stipulated that you own an interest in 25496. Right now, Mr. Savage was making the argument that you're not negotiating in good faith. I'm not agreeing with that, and I'm not going to support that for now. So I'm allowing Mr. Savage to present 3 of his 4 cases by affidavit today, because your entry of appearance is struck. It is omitted now in those 3 cases. So you can listen to this. The other case is contested, so it will be moved. Mata E, please move 25496 without charging Alpha Energy Partners to the August 21st status conference docket. Mr. Anderson, you're encouraged to participate at that status conference. I'll call on you as long as you're there when I call the case. And we can hear what your objection is at that time, and whether or not, your negotiations are ongoing with Alpha Energy. And in the meantime, Mr. Savage may file a motion, which I will look at and you will look at as well. You will have the opportunity to respond to that motion and make your case. But we'll see you again at least on the 21st of August at the next status conference in 25496.
And Mr. Herrington, if I could just clarify, I'm not sure if we're claiming that he's making it in bad faith. It's more of unreasonable requests that are outside the scope of the market. And
I've seen, Mr. Anderson did include some terms of negotiation in his objection. So I've seen some of that information.
Yes.
But I don't believe that I have the authority to declare that that is outside the scope of or the market boundaries. Mr. Anderson, you wanted to say something?
Yes, sir. What I was saying was, I since the first case in back in 2024, I've been trying to negotiate and talk to Alpha, and I've talked to Mr. Kaufman just recently and before, and I've always been trying to negotiate in good faith. I believe that Alpha hasn't been trying to negotiate with me, because I'm the one reaching out to Alpha.
I understand. And I read the document that you emailed to the hearing clerk. I read it thoroughly. So I already knew, that you've been trying to negotiate for a while now. But we have a certain procedure we go through here. And if a party owns an interest and they object, then the case cannot be heard by affidavit. That's how we're going to proceed. So is there anything else before we hear these other three cases by affidavit?
Mr. Hearing
No,
Examiner,
thank you.
I'm sorry.
Okay, thank you, Mr. Anderson. Mr. Savage?
Yes, Mr. Hearing Examiner, I believe that American Energy entered an objection today.
Ah.
And I believe Mr. Samaniego is online, so we probably should address his concerns.
Well, if Mr. Samaniego has an objection to, Mr. Samaniego, is it all four cases that you're objecting to?
Yes, I believe all four.
Is that what you understand also, Mr. Savage?
That's what I saw in his objection, but if I can explain the basis of our opposition to that objection also.
Okay, go ahead.
Okay, so we ask that you strike the objection and the appearance. American Energy is not entitled to receive notice because it has no interest in any of the units within the four cases. Mr. Kaufman is available online to confirm that and is available for any questions.
All right. Mr. Samaniego, are you saying that you have a working interest in these four cases?
Yes, American not only owns working interest, but operates its well, the site number 1.
Okay. All right. Do we have Mr. Kaufman?
Mr. Kaufman?
Yep, I'm here.
Okay. All right. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
Great. Would you spell your name?
JOHNCOFFMAN.
Okay, great. And just speak up a little louder so the microphone picks up your voice. Have you been previously qualified as an expert before this division?
Yes, I have.
In what field?
Land.
Okay, very good. So, Mr. Savage, I'm going to give Mr. Samaniego an opportunity to cross-examine your witness, but first, and we're only talking about Mr. Samaniego or our American Energy Resource interest in these four cases. So would you go ahead and examine your witness based on that issue?
So, Mr. Kaufman, did you do a tidal analysis for the units proposed in the four cases?
Yes.
And in your tidal analysis, did American Energy or Mr. Samaniego or any affiliated party appear as an owner of working interest in any of those units?
No.
So, you heard Mr. Samaniego talk about this site number 1 well.
Yes.
Can you explain why he does not own any interest in that particular unit, any working interest?
I believe his interest is wellbore only, and it's in the north half of 17, and the well hasn't produced in a number of years, so those fee leases have expired if he had owned them in the first place. But I believe it's a wellbore interest only, and therefore he wouldn't be entitled as a working interest owner.
So it's fair to say that whatever leases that were associated with that well outside the wellbore have expired?
Correct.
And would that mean that he has no working interest within the unit?
Correct.
And would it be fair to say that it's even likely that those leases that held the wellbore expired?
I know for a fact that they have expired.
So would it be fair to say that he doesn't even have any wellbore interest in that regard?
Yes. I think depending on the contractual agreements, but yes.
Thank you, Mr. Kaufman. That concludes my examination.
Okay. Mr. Samaniego, the issue here is whether or not you have a working interest in these four cases. You have a witness who has just given me evidence that you do not, but you have the opportunity to cross-examine this witness. So would you like to do that?
Yes, I would.
Please go right ahead.
Mr. Kaufman, in your search into Americans' interest and your conclusion that Americans' interests are terminated, under what standing with merit that validates that termination